The first question is not, can the aircraft land here? It is, what kind of import is this? Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. In this discussion, I want to talk about aircraft import considerations in a way that is practical, memorable, and grounded in the actual rules that govern the transaction. Let's begin with the mistake that causes trouble at the very beginning of an aircraft import. People say, we are bringing the aircraft into the United States as if it were a single act. Legally, it's not. It can be a permanent import for U.S. ownership and operation. It can be a temporary import. It can be an aircraft entering for repair. It can be an aircraft entering under a structure that is duty-free under the civil aircraft rules. Or it can be an entry that triggers customs exposure, state tax exposure, and certification issues all at once. And this is why the first practical question is not, where is the airplane? Where is it flying? The first practical question is, what is the legal status, the import, and the type of import that is supposed to have? On the customs side, aircraft are still merchandise under Title 19 of the Code of Federal Regulations governing entry procedures administered by U.S. Customs and Border Protection. Title 19 C.F.R. Part 141 sets out general requirements for entry of merchandise, and Part 142 addresses the entry process. If the aircraft is being brought into the United States for consumption entry, the importer needs a clean customs strategy, accurate paperwork, and the right tariff treatment from the beginning. And this is where many clients are surprised. In the aircraft world, customs problems do not come from dramatic misconduct. They come from category errors. A party treats a permanent entry like a temporary one. A temporary use becomes a de facto permanent presence. A buyer assumes that because the aircraft is civil, it is automatically duty-free. And these assumptions can be expensive. The tariff system still matters. Under the Harmonized Tariff Schedule, General Note 6 implements the Agreement on Trade in Civil Aircraft. The rule can permit duty-free treatment for qualifying civil aircraft engines, parts, and components. But the key word is qualifying. The exemption is not a slogan. It is a status that has to be supported. The importer must be able to show that the aircraft or article fits within the civil aircraft framework and that the entry was made correctly. Remember this, an aircraft can be duty-free and still be imported wrong. That matters even more where the aircraft is only coming in temporarily. Title 19 also allows temporary importation under bond. Under 19 CFR Part 10, Subpart B, temporary importation under bond, related Customs Border Protection guidance, goods not imported for sale can come in under bond for a limited period, generally with the expectation that they will be exported or destroyed within the regulatory time limits. That can be useful where the aircraft is entering for a defined temporary purpose. But it is not a magic parking permit. It is, if the operational facts do not match the bond entry, the structure becomes fragile very quickly. There is a related misconception in business aviation that deserves to be corrected. Entry into the United States for customs purposes is not the same thing as FAA registration. And FAA registration is not the same thing as airworthiness approval. Those are different gates controlled by different legal systems. A transaction can clear one gate and then fail in another. Practically, Import planning should therefore begin with a 4-part customs checklist. First, identify whether the aircraft is entering permanently, temporarily, or for a limited service-related purpose. Second, identify the importer of record and make sure that that party actually matches the ownership and funds flow structure. Third, classify the aircraft and determine whether duty-free civil aircraft treatment is truly available and documented. Fourth, coordinate customs treatment with tax planning and the FAA plans so that one workstream does not quietly sabotage another. This is where experienced aviation counsel, customs counsel, tax counsel, escrow professionals, and the broker all need to speak to each other before the aircraft moves. The market often treats import as a logistics exercise. It is really choreographed sequence. In short, the first segment of this analysis is simple. An aircraft import begins as a classification and entry problem before it becomes anything else. If you answer the first question incorrectly, every later answer gets harder. Here's a takeaway. In aircraft imports, the flight to the United States is transportation. The import itself is a legal characterization. Thank you for your interest in this topic. This information is provided for informational purposes only and should not be construed as legal advice. Please discuss the facts of your matter with a qualified aviation, customs, tax, and regulatory counsel before acting. We welcome questions, and if you have any questions, please direct them to admin@aviationlegalcounsel.com. We look forward to assisting you navigate these issues with precision.